This is the appointed time, and we have a quorum. So I call this meeting to order. Let's invite the administration in first. So, may I welcome representatives from the administration. This is the first meeting of the Bills Committee in the year of the goat, and I wish everybody a Happy New Year and good health. So, at the last meeting on the 9th of February 2015, regarding the issues raised at the meeting, the administration has given a written response. The paper is LC paper CB bracket 2 903/1415 bracket 02. And about the concerns and issues raised by members at the last meeting, the list of follow-up actions is paper number 903 bracket 01. So I'll invite the administration to walk us through the paper first, and I'll see if members have follow-up questions. Mr. Chan, please. Thank you, Chairman. Good morning, members. Now, in relation to members' concerns raised at the meeting on 9th of February 2015, we have prepared a written response which have been forwarded to members and the Secretariat. I'd like to supplement on license renewal. At the last meeting, members asked about the procedures and the time required for license renewal. They've also given us very valuable views, and we're grateful. We understand that in relation to license renewal for PMCs and the personnel involved, it's very important because it hinges upon the livelihood of practitioners, PMPs, and also the property management work of the housing estates concerned. Therefore, the procedures for license renewal should begin as soon as possible to ensure that the Property Management Services Authority, PMSA, would have sufficient time in processing the applications. We will put in place a set of procedures to ensure the rights of PMPs as well as property owners. First of all, application for renewal can be made 3 to 6 months before the license is to be expired, as there are factors to be considered for license renewal with a lot of documentation involved. We propose that the license renewal application be made 6 to 9 months before the expiry of the license. We also propose that if the PMSA still hasn't received the renewal application from a PMC 6 months before the expiry of the license, the OC concerned and the property owners would be informed by the PMSA for them to confirm whether the PMC would renew its license. Because if the PMC is not minded to renew its license, the OC could then consider engaging another service provider. We'll also draw reference from other licensing regimes. For example, we'll draw reference from the accommodation and guest house ordinance. In that if an application for renewal has been made before expiry of the license, and if for a number of reasons the PMSA still hasn't decided to renew the PMC's license before its expiry, then we will allow the license to continue to be valid for the time being. And we also propose to put in place some transitional arrangements. For example, in the event that the PMSA rejects the renewal application, to ensure that the property owners and the OCs concerned would have sufficient time to engage another service provider, the PMSA can, based on actual circumstances, allow short-term exemption, say for 3 to 6 months, so that the PMC could continue to serve the existing housing estate and to allow time for the property owners and the OCs to engage another service provider. Now, regarding renewal application made after the expiry of the license, say because the PMC has simply forgotten to make the application, the PMSA also has discretion to accept such late applications. Also, at the last meeting, a member asked if for some personal reasons a PMP decides not to renew its license, what would the PMSA do? As the licensing conditions or licensing criteria for PMPs are based on the qualifications of the PMP and experience, the decision not to renew the license for the time being would not affect the PMP's qualification or eligibility in renewing the license in the future. Thank you. Now, before I ask members to ask follow-up questions, I have questions for Director, Mr. Jack Chan, because what you have said is not in paper 903/02. So would you please give us another paper setting out your response to the suggestions made and your proposals so that we have a better idea?
回覆同埋頭先陳處長即係嘅補充咧，有冇
Because in relation to Mr. Chan's supplement, I'd like to know if there are questions from members. All right, if there are no more questions, now we can move on to the clause-by-clause scrutiny. Last time on the 9th of February, we stopped at clause 10. So we can start with part 3, clause 10 of the Blue Bill, which is page C2748 in the Chinese version, or 2749 in the English version. So, over to you, administration. Would the administration please explain the clauses to us to facilitate our scrutiny? Thank you. I'll ask Mr. Franco Kwok to explain the clauses, and we'll be happy to take questions from members. Thank you, Chairman. Well, last time members completed scrutinizing clause 10, and we'll start with clause 11. And based on sections 9 and 10, in granting a license, the PMSA would need to consider whether the persons holding the licenses are suitable persons, and this is in clause 11. This clause is quite long because we need to set out clear requirements based on different scenarios. Basically, the considerations are similar. Basically, consideration will be given to the financial status of the applicant, and also whether the applicant has any record of breaches. Now, whether the individual is, whether the applicant is an individual or a part of the company, etc., or for a partnership, we need to consider whether, first of all, the individual or the partner or the company is an discharged bankrupt, and also whether in the 5 years before the relevant application he has entered into a composition or scheme of arrangement with the creditors, and also whether the applicant has been convicted of a criminal offense involving fraud and dishonesty, or whether he has been convicted of a disciplinary offense or a criminal offense under this ordinance. And in relation to a company or a partner, we also need to consider whether the person is a mentally disordered person under the mental health ordinance, and whether that individual is an officer of the company, and whether the authority has in the past rejected any application in this regard. As regard the definition of officer, it has the meaning given by Section 2(1) of the Companies Ordinance, Cap 622. That means the person being an officer should be a director or a company secretary. And if the person is a director, then the person should be a suitable person for holding a license, regardless of whether the director, whether or not he is a director or he's the applicant is a company. The considerations are the same, and this is for considering Tier 1 and Tier 2 license. And the factors or considerations are the same as what I've mentioned just now. Any follow-up question, Mr. Wu Shiwai?
Wu Shiwai. Thank you, Chairman. Simple inquiry. For the catering industry, in the past, there was a period when, what we call, changing shell. That is, a company declared bankruptcy and then it re-entered the market through a shell company. So under this system, just looking at the wordings in the bill, when we consider whether to issue a license to the relevant company, what about the composition of shareholders? Is the composition of shareholders something that needs to be considered or not? I'm just thinking about, for example, in the past, we've seen many cases, in which a company became bankrupt, declared bankruptcy, and then it again re-enter the industry or the market using another company name. So do we have any sort of restriction imposed so that this sort of behavior will not appear, or the chance of this happening is lesser? Thank you, Mr. Wu. This is an important consideration to us. I think during the consultation period, we did consider this issue in depth. We were worried about the scenario happening, that a company after getting a license, after it's been asked by us to cancel the license, and yet we restructure later on and then get together the same group of people to get a new license. We do want to rid this sort of situation out. I think we would look at not just the registered address of the company, but also we would check all the information of its shareholders. If a company had the precedent of violating the rules or even had criminal convictions, then we would really keep that on record and carry out due investigation. When the time comes for its shareholders or the company to reapply for license, we'll check whether the shareholders or the company had involved in criminal cases before. So, Director, are you referring to? Can you tell us clearly where we can find what you said in the bill? Where can we find the information in the bill, Director? Mr. Kwok? Please go to section 11, 2B, point 6. That is, each shareholder has to be someone appropriate. And in part 4, we will give further elaborations. In part 4, it's stated very clearly that if a member actually was a sole proprietor before, or was a senior member of another, troubled company, then that could be a ground for us to consider whether they are suitable to be running the company again. So it's something for the future PMSA to consider, but doesn't mean that for example, in a case where someone was convicted, that person could still be considered for setting up the company, right? Considering the nature or the seriousness of the offense in the past, right? Yes, your understanding is correct. Would you like, Vice Chairman? Can you clarify further? So based on what's written in the terms, in the wordings, the company director, that is whether the director had been, rude, that ruling had been passed on them, that they had violated the law. So if you want to decide on whether a company has violated the law or regulations, will the adjudication itself actually be applied to the company shareholder? Yeah, Mr. Chen. We will look at the basket of factors and whether the shareholders of a company have violated the law or breached any regulations. That would be something to be considered. But as someone said earlier, but that may not necessarily mean that the license will not be issued. It really depends on the case. Chairman, let me make it clear. We know that when we make a ruling on whether a company had violated the law, we would look at the person involved. The company could have violated the law, but company is a statutory body. And we want to see whether a company itself had violated the law. So is it that a ruling that decides that a company had violated the law would be applied to shareholders of the company? Yes, Chairman, it really depends on the case itself, whether the legal entity embodied by the company was rude to have violated the law, and if in that case of violating the law and the shareholders were directly involved, then of course the shareholders would be liable. But it really depends on the situation. So Mr. Kwok can supplement. Yes, in 11.4a, actually paragraph A covers the individual behaviors, whether the person, for example, had actually been involved in criminal offense. But if it's a senior, but for other situations, the PMSA could consider whether the shareholder is an appropriate person to be involved in the company or to hold licenses for the company. I think the PMSA can consider a host of situations and factors. So in other words, when we have a ruling on a violation of the law that's applied to a company, then the ruling itself would be directed at certain directors, right? Yes. It really depends on the case. That could be the case, but so the ruling could be targeted at one particular shareholder or some senior officers. So it really depends. So members, any other follow-up questions? Mr. Kwok, if not, please carry on. Let's go to section 12 now. Section 12 states that the authority must from time to time by notice publish in the Gazette publish a list of licensees, including their names and license numbers. And section 2 states that notice published under subsection 1 is not subsidiary legislation. Questions? Earlier on, someone mentioned about the information involved. Apart from the Gazette, are there any ways for the public to find out about this information mentioned here? Well, this is what's covered by Section 13 registers. If they have no questions, Vice Chairman? Yes, just want to clarify something. Here it says that the authority must from time to time by notice publish in the Gazette publish the list of licensees. Can I look at it this way? That on the list, so the companies or the names on the list before the name was revoked, as long as the name is on the list, that they are effective licensees, right? Yes, that's correct. So in other words, if the PMSA wants to revoke a license, then it will make an announcement instantly, right? Yes, your understanding is correct. So from time to time, meaning instantly. Yes. Of course, it may not mean the next second or the next minute, but we'll remove the name as soon as possible if it's needed. As for behavior that violates the law, actually later in the bill, we would indeed publish in the Gazette any offences committed by licensees. Okay, please. You call him. You said that it would. That you say that there will be a license number published in the Gazette. Is this a permanent number? That is, even if someone gives up some of his license and when he picks up the business again, he will still be given the same license number? Well, for such a detailed question, we haven't yet made a decision on this yet. I think after the PMSA established, it will consider, whether the license number should be a permanent one for a particular person or not. But I think maybe it's clearer to have a permanent number, permanent number assigned to a particular person. So I think you could consider this. You can make this a permanent number for a person. Yes, this is a good suggestion, and we'll follow up on it. Vice Chairman? But another thing, of course, it won't be a problem if it's a personal, license, someone who's holding a license. But what about a company license? It's a company holding a license. So would this license number follow the company forever? Would it be a special number for a company? License number is in itself a kind of asset. Mr. Chen, please consider that, follow up on it. Okay, please, Mr. Kwok, carry on. 13, Section 13, the registers. It's stated here that the authority must keep a register containing information of the licensee so that the consumers can, under the one-tier system, have full grasp of the information to help them make the right choice. It should contain the number of licensees and the number of flats managed by the company. The PMSA need to keep 3 registers. That is that's a PMC register, Tier 1 register, Tier 2 register, and also a PMC register must for each licensed PMC contain the name and address of the PMC and the period for which the PMC's license is issued, and if applicable, the period for which license is renewed. the number of household units that actually under one or more deeds of mutual covenant may be used for residential purposes and for which property management services are provided by the PMC. And also subject to Section 2 of the relevant ordinance, the conviction record of the PMC in relation to disciplinary offences or criminal offences under this ordinance. And Section 2 mentioned the Tier 2 register, but similarly, both types of registers need to contain the name of the PMP's license number, the period for which the PMP's license is issued, and a statement as to whether or not the PMP is a director of a licensed PMC, and also any criminal records or records of criminal offences.
Okay.
Subsection 6. Now, the purpose of the registers is to enable the member of the public to have access, and the register should be made available for inspection free of charge at the offices of the authority through the internet or in any other manner the authority considers appropriate, and the purpose is to check and ascertain whether the business entity is a licensed PMC, whether an individual is a licensed PMP, and the particulars of the licensed PMC or PMP. And subsection 7. The content of the 3 registers must not include particulars of a criminal record. Subsection 8. On payment of a prescribed fee, any person may obtain from the authority a copy of the whole or part of a register kept by the authority. Any questions from members? Yes, Deputy Chairman. A question. Now, company structure may change. There may be change in company personnel. Is there any provision that requires the company to update the register, and that it should be updated within a certain time frame? Yes, Mr. Kwok. There is no explicit requirement in this clause. However, in clause 17, it is provided that the licensee has a duty to notify the authority in relation to any change of the company. So on receiving such notification, the authority may update the register. So it will be put in the code of practice later. No, it's in clause 17. It is the licensee's duty to notify the authority of any change. Now, let's say if the composition of the OC is changed, then within a month, such change is to be notified to the Lands Tribunal. I don't know whether there will be similar arrangement here, because we may be quite concerned about the change in company structure or the number of properties that is under the management of the PMC. I don't know whether we have similar arrangement in the bill. Let me supplement. This is an important issue, and at the consultation stage, we did discuss in great detail. Now, in order for the regime to be effective, we need to have accurate and up-to-date information. So it will be the licensee's duty to keep it up-to-date, and we're going to require the licensee to inform the authority of the change within certain days, and the authority will also be required to update its website and register within certain days on notification of the change for public access. But should we put this in as part of, as the corresponding detail? We believe the clause should suffice, because we already imposed a duty on the licensee. The code in the future would set out the details, in relation to the time frame, whether it should be 2 weeks or 3 weeks. Otherwise, it would constitute a breach. in future, the code will be made available to the public through the internet, etc., and also the PMPs and PMCs. And it may also be posted in a conspicuous place in the housing estate. These are details. Let's hope that they would give this a thought when they prepare the code. These are all good suggestions. We'll follow up on them when we prepare the code. Mr. Yip Kwok Him, before I ask a question, I have a suggestion. Some clauses are longer, so please spend more time on it. For example, clause 13 contains matters relating to inspection of the register, so on and so forth. So I think they should go through it page by page and bit by bit. The clause is too long, and we may easily overlook the matters of our concern. Now back to my question. You mentioned that the PMC register must contain certain information, C2761 in the English version, subsection 2. Altogether, A to I, and then last provision I. Any other particulars the authority considers appropriate. This is very wide. Why is that? Is it because you want to give more room or flexibility? Because in fact, you need to be concise. Which information is needed, which is not. Well, in fact, at the consultative committee, we also discussed the same. Or the advisory committee, we also discussed the same. For items from A to H, these are the areas of information required. However, members also opine that because of social changes, there may also be new information needed to be inspected by the public, and therefore they considered it necessary to have some flexibility to include item I, so that information required by the committee and the public can also be set out in the register for inspection. Any follow-up? Now, the information required is set out in the bill. The purpose is to make it more flexible by putting down item I. But let's say in the future, if you want new information to be put in the register, do you need to come back to us to amend the ordinance, or can the authority decide on its own? Well, this is in fact not something new. We have drawn reference from other similar legislation, such as the one for the airport authority. Well, basically, this is just for putting the particulars of public's concern in the register. So does it mean that in future, if you want to add more information to the register, can you give us an undertaking here that you report to our respective panel, let's say the panel on Home Affairs, so that members would stay informed, because this may be important information. All right, if there are substantial changes in relation to the information required to be put in the register. Yes, we will require the PMSA to submit the work report to the Director Bureau, which will set out the matters mentioned. The report will also be submitted to LegCo. Yes, I accept this arrangement. Mr. Leung Chi-Chao. My question is actually similar to Mr. Abe's. about disclosure of information of the PMP and PMC. It's already regulated by the law. For example, C2760 talks about disclosing information online. And then 3E provides that subject to Section 2 of the Rehabilitation of Offenders Ordinance, and then so on and so forth. I mean, we already have a provision on what information can be disclosed and the scope of information can be disclosed. If you give this too much flexibility, then this provision can be circumvented and all information can be disclosed. I think there is a concern over disclosure of personal data, in particular on disclosure of criminal record. Now, some property owners may wish that criminal records of the licensees be disclosed. Now, if there is flexibility, then when an appeal is lodged, does it mean that the authority could circumvent the provision and make disclosure? Thank you for your comment. Now for the subsection A to E are mandatory requirements, whereas F is more flexible. Say if the conviction record doesn't need to be disclosed according to the Rehabilitation Offenders Ordinance, then F will not come into play, so it will not be affected. Vice Chairman. Thank you, Chairman. I have another follow-up question. Giving more flexibility to the authority. Well, I don't know whether how it is going to operate, because the authority may have codes of practice, guidelines, and there is a clause stating that it should, from time to time, it should observe the codes and guidelines issued by the authority from time to time. I don't know whether they're required to observe the law and comply with the law in relation to acts not included in the ones we mentioned just now, because the authority will publish from time to time codes and new requirements requiring licensees to observe. So does it mean that if there are new requirements that they should observe, new disclosure requirements that they should comply with, shouldn't it be done by way of amending the ordinance in order to give it more priority? Otherwise, you can just generalize the requirements by stating that the licensees must observe the codes and guidelines issued by the authority from time to time. So you're suggesting that the authority you're concerned because even though not all the details are set out, the authority may still impose new requirements in the future. So in effect, it's no different than setting out all the details in the primary legislation. This is in fact a kind of a best practice. I think this is members' concern. Your response? I understand the members' concern. However, we find this flexibility necessary. As mentioned just now, for other authorities and other relevant bodies, there are similar requirements for licensees. At the advisory committee, we also agreed that flexibility should be preserved for the operation of the authority in facilitating development of the industry and upgrading the quality of service and safeguarding the rights of property owners. Well, perhaps I didn't make myself clear. Well, let me rephrase. The law implies that the authority will from time to time publish codes and guidelines setting out the scope of requirements that are to be observed by licensees. But what I'm thinking about is that in relation to new requirements under this several subsections, they should appear in the form of subsidiary legislation, meaning that they should carry a status higher than the codes and guidelines.
So I don't think they're directly related. Here is that the PMP, whether it's a company or individual, would need to provide to the authority their information for a disclosure to the public. It's not to do with the code of practice. It's stated very clearly in the law that the petitioner needs to put down his name, license number, validity period of the license, whether he has any criminal record, and any particulars the authority considers appropriate. So any particulars that should be disclosed to the authority. Yip Kwok-hing? Yes. I think this is not a code of practice. Because in this section, the information to be provided in the register, I think this is something that actually can be required clearly by law. And there also needs to be the flexibility given. I think LegCo can play a role here. If you think there's a need for this particular, of course, you can ask for it for supervision purpose. But this is something to do with a provision of information. With advancement in technology, what sort of information should be provided as well for the public to know. In relation to, information that the public should know, about a company. I think members are maybe worried about how to strike a balance. Whether, some requirements may be too much, or we're asking too much from licensing and so forth. Vice Chairman, I think that for this section, I share, your view, Mr. Yip. I know this is nothing to do with code of practice, but I was thinking that if the authority thinks that some sort of information should be disclosed, then on top of what's mentioned here, then shouldn't that be included in a subsidiary legislation so that we can have the introduce the vetting procedure? Because if it's the whole law, then there's no need. If it's just something for the general compliance requirements, then that's fine. But I think the way that it's written here, it empowers the authority to list the kind of information that it considers needed to be disclosed. So I think as Mr. Yip Kwok-hing said, that should be a vetting mechanism offered, so that LegCo can have a say and can look into, the extra or the information the authority wants to see disclosed. Because it's not something to do, I know this is not to do with code of practice, but it's some kind of legal requirement. So should we look at having the subsidiary legislation? Mr. Chen? Yes. I think what it means here is if the authority at a certain point in time thinks that certain information needs to be disclosed, if we do not have this section in the bill, then whenever there's a need, we would need to come back to LegCo and ask for an amendment of the law to facilitate disclosure of information. That could be quite a cumbersome process. Let me give you an example. In the future, maybe there could be a law asking companies to comply with certain new environmental protection laws. And the authority may think that, well, the owners' corporations, the public may want to know whether a particular property management company has got the certification for environmental protection. So as a flat owner or owners' corporation may want to know information like that. If we now have this section here in the bill, then by then the authority will be empowered to ask the licensee to disclose that sort of information. But according to the suggestion by the Vice Chairman, based on the Vice Chairman's suggestion, then in the future the authority wants to ask for that sort of information, then the authority will need to come back to LegCo to ask for agreement or approval of the extra requirement by law. And that would make the process a bit complicated. Well, we can assume that the authority will be reasonable. Well, I'm not saying that the authority will not be reasonable. I never doubt the role of the authority. I was just saying that if there's a difference here, if the authority, of course, you can come up with your own code of practice, and non-compliance with the code would not lead to any criminal responsibilities. Non-compliance would only be used as some sort of evidence. But now on this issue of disclosure, now if we empower the authority to ask for disclosures of information, so my question is this clause on empowerment, even if we want to speed things up, should we actually introduce a subsidiary legislation instead to empower the authority? I want to do things quickly, but as we've said in the past, negative vetting is a speedy process. It's just whether you think the authority should go through the legislative stage first before coming up with disclosure requirements. Yes, I think I do understand the Vice Chairman's view, but I think it's a matter of striking a balance, balance between efficiency and addressing public demands. It still takes time, to complete the process of vetting. So maybe a committee under the authority can, make decisions and go for amendments later on for important issues like where the or if for unreasonable requirement, if there are to be unreasonable requests made by the authority, I'm sure there will be public concern and the government will be asked to take follow-up action. Any supplement from the director, legal advisor? Thank you, Chairman. I want to ask about two sections. 2H. First is on 2H. About the information to be put on the register by the PMPs. In 2H, it says Subject to Section 2 of the Rehabilitation Offenders Ordinance, the conviction record of PMC in relation to disciplinary offences or criminal offences under this ordinance. Firstly, my understanding is Section 2 of the ordinance only applies to individuals, but now you are applying this section to a company, to property management companies. Of course, it can be a company can be a sole proprietorship, but then most companies, would have more than one persons in charge. So the rehab of offenders ordinance really is not applied to companies. So how can we implement it? And secondly, if the criminal act offences of a company actually involves directors of company, then would that rehab of offenders ordinance be applied to the shareholders? So should we ask the shareholders to disclose the relevant information? I'll ask our law draftsman to answer this question. Yeah, legal advisor's point is valid. The rehab of offenders ordinance is only applicable to individuals. Therefore, 13(2)(h), what is carried here, the company mentioned here, the property management company, should be one of a sole proprietorship. It's only, for sole proprietorship that this Section 2 will be applicable. Otherwise, it will not be applicable. Your second question on whether shareholders should be covered. Shareholders are not the PMPs, so therefore the section will not be applicable to shareholders. And Section 11 says that the authority will consider the criminal records of a company's criminal records. So have you considered that the criminal records of shareholders should be something to be disclosed? Director. Yes, I think we'll talk about the consideration for issuing a license. In issuing a license, we'll consider the shareholders and the company. But when it comes to disclosure, we will ask the company to make a disclosure. So directors of a company are different. So what this law requires, I think, is already enough, and we don't need to ask for. So there's a distinction made there. You also said that 2H is not applicable to companies, but companies could also have criminal records or have been convicted of criminal offences. So if Section H is not applicable to companies, then would it be incomplete? I think we're talking about applicable to companies when it comes to disclosing. I think we're talking about applicability when it comes to disclosure of information. So the rehab of offenders ordinance will only affect an individual, not a company. Claudia Mo, next. Thank you, Chairman. I'm a bit confused now. You are talking about the ultimate disclosure. That is, ultimately, the companies will be obliged to make disclosures, and companies would not be. I'm very, very confused by Section 2H. Are individuals, what are the individuals' responsibilities? Okay, Mr. Kwok. I think for Section 2H is if a company has violated the law or has any criminal record, then all companies need to disclose that. But if the company is a sole proprietorship run by one individual, and then under the rehab of offenders ordinance, then the sole proprietorship supervisor would not be required to disclose the record. But for the company itself, all its previous criminal records need to be disclosed. Claudia? In other words, if it is a sole proprietorship, then if anything happens, then according to Section 2H, then that sole director or owner of the company would not need to make any disclosure. Yeah, Section 2 makes it very clear under what circumstances do the person involved do not need to make disclosures of his previous criminal records. For example, sentences that carries a fine of under $10,000, or that actually
Well, perhaps we can redraft subsection H. For example, we can divide the two parties. I think if in the case of individual, then the section H should apply. In the case of the company, then the section H should not apply. Mr. Ibrahim? Yes, if there is a criminal record in relation to the company, then of course it should be disclosed. If the company is running on sole proprietorship, then the criminal record of the individual should not be disclosed. So to clarify the point, disclosure through the internet or through electronic network, well, then this part should not apply. Am I understanding correctly? Yes, we want to facilitate the public's inspection of the registers. So most of the information could be put online for inspection. But as some information may have to do with privacy, this part of information will not be made available online. And yet the public can still inspect the register at the offices of the PMSA, etc., although they may not make photocopies. So about subsection 7, the contents of the registers must not include the particulars of a record mentioned in subsection 2H, 3E, or 4E. But subsection 2H has to do with the company, whether there is any record of breaches or criminal records of the company. It is important. So why is subsection 2H also exempted from being made available on the internet? Well, perhaps we can follow up on this point and improve the drafting of the provisions. Deputy Chairman, well, legal advisor just made the point. It's not just about improving the drafting of the provisions. If there is a breach, if there is a criminal record in relation to the company, then personal data privacy should not apply. And I think legal advisor's point is that the company's records should not be exempted from being made available. Yes, understood. Perhaps, Mr. Chan, you can supplement. We think that the two should be separated. Protection of privacy. Now, protecting a person's privacy is important, whereas for a company, such breaches or criminal records should be disclosed. I think you need to amend this. 2H. Mr. Ibrahim. Yes, I agree strongly with the view of the legal advisor, so please consider separating the two. You should require the company to disclose its record, but not the individual on the internet. Clause 13 has a number of subsections. So perhaps we should go through them one by one. Clause 13, subsection 1, any questions? No. Subsection 2, A to I, any follow-up questions? Subsection 3, A to F. Subsection 4, A to D. E and F. Five A to C. 6A to C. 7, 8. Now about 7. The register is available online, but printing is not allowed. Is that right? You can browse or print the content from the internet. But as I said just now, those involving a person's privacy cannot be viewed or printed. Now, subsection 8 says that if you want a copy, you need to pay a fee. Does it mean that there is information not available online which you can make a copy of? Now, for the information that contains a person's privacy data, the copy cannot be made, but the person can browse through the record or the register at the office of the authority. So does it mean that by paying a fee, the person can obtain a copy from the authority of the information? Right. Yes, Deputy Chairman. Chairman, because subsection 8 says the person may, on payment of the prescribed fee, obtain from the authority a copy of the whole of a part or part of a register kept by the authority. The whole of a register should mean the complete register, including personal data. So is it contradictory to what you said just now? You're right. We need to make amendments and exclude the part of the register involving personal data privacy. So this part is unclear as well. Any other follow-up question from members? If not, then Mr. Kwok may continue. Clause 14 now. Clause 14.1. Mr. Kwok. Thank you, Chairman. Clause 14 has to do with offence relating to application for licenses and renewal of licenses. Subsection 1. A person commits an offence if the person, in connection with an application for a license or the renewal of a license, provides any information or document to the authority that is false or misleading in a material particular, or a person knows that or is reckless as to whether the information or document is false or misleading in a material particular. Thank you, Chairman. Yes, Ms. Claudia Mo. Thank you, Chairman. Well, I'm not in the legal profession, but I see this is quite vague for PMCs and PMPs. What is meant by material particular? And also, what is meant by misleading? What is the line to be drawn? And point B, knows that or is reckless as to so and so. Now, one might be very concerned whether inevitably the person may fall into the trap. Yes, Mr. Lam. For offences relating to application for licenses, usually the offence involved may be providing misleading or false information. They are just general provisions. As to whether what is meant by false or misleading information, we need to decide on a case-by-case basis. So what is meant by material particular? I think it may be something quite minute. Say I fell a tree, and then I said I didn't fell a tree. I don't think this is a material particular. I may not think so, but you may think this is a material particular. Yes, who'd like to take the question, Mr. Kwok? I think in English it's material particular. That means when the authority considers the information for whether for application for licenses, they would consider whether the material is false or misleading. And of course, we need to decide on a case-by-case basis whether the information is false or misleading. Well, I think on the application form, and there may be entries that you must fill in, and there are also optional entries. No other questions? Mr. Kwok, please continue. Bracket 2. Subsection 2. A person who commits an offense under subsection 1 is liable, A, on conviction on indictment to a fine of $200,000 and to imprisonment for 1 year, and B, on summary conviction to a fine at level $100,000 and to imprisonment for 6 months. Thank you. Any questions? So, Mr. Kwok, would you please continue? Clause 15, bracket 1. Thank you, Chairman. Clause 15 enables the authority to make regulations. In relation to Part 3, the authority may, by regulation, prescribe, for example, the information to be obtained in and the documents to accompany an application for a license or the renewal of license, the fees payable in an application for a license or renewal, the criteria for holding a license, the fees payable for the issue of a license, renewed license, the conditions that may be imposed on a license or renewed license, and finally, the fees payable for a copy under Section 13.8. Thank you. Any questions from members? No? Mr. Kwok, please continue. Subsection 2 now. Subsection 2 sets out the criteria mentioned in subsection 1c. That is the criteria for holding a license. Here it provides for a PMC license may include a criterion that the person has a sufficient number of directors and employees who are licensed PMPs. And for PMP Tier 1 license or PMP Tier 2 license may include criteria relating to the person's academic qualifications, professional qualifications, and relevant work experience, and may impose more stringent requirements for a PMP Tier 1 license. And earlier on, we submitted a paper to the Bills Committee setting out our preliminary view on the requirements for Tier 1 and Tier 2 license. Mr. Yip Kwok Him. A question on the Chinese version. That the person has a sufficient number of directors and employees. And what does that mean? A sufficient number of directors and employees who are licensed PMPs. But what does the person has means? Can you explain this in Chinese? Now, for the person, we're talking about the company making this application. The person. So you should say the company, but because this is for a PMC license. So the person means the applicant. That means the company should have a sufficient number of directors and employees. So does it mean that the words the person is are superfluous? That means the company should have a sufficient number of directors and employees who are licensed PMPs. Would it be easier to understand? Yes, who would take the question? Your comment, Mr. Lam? Thank you, Chairman. We're talking about the PMC license. So it's about the PMC having a sufficient number of directors and employees. So here, the person doesn't specify actually who should have a sufficient number of directors and employees. But you're referring to the company, right? Even in the English version, you cannot delete the words "the person." Maybe we'll go back and consider it. Because in English, if it says "the person," then in Chinese, there should be a corresponding term. And we may need to find a way to correct both versions. Because you're talking about a company, and then you may include a criterion. Well, for example, that you should have a sufficient number of directors and employees who are licensed PMPs. Yes, go back and think about it because we are reading the Chinese version. So we'll focus on the Chinese text. This is somewhat confusing. So would the administration go back and think about it?
Paul Chair, 15C says that the authority may by regulation prescribe the criteria for holding a license. And 15 bracket 2 B 1 and 2 also give further details. But this is something that when vetting the bills, we asked a lot. Are we opening the door to these criteria, even though there could be a procedure of negative vetting? But since in section 11, there have been some requirements on the licensees. Now, are we opening another door, and to criteria that may actually not be scrutinized by LegCo? B1, it says person's academic qualifications, professional qualifications. Are we opening up actually too wide a back door now? Mr. Chen, I think the actual requirements will be actually laid out in subsidiary legislation to be vetted by LegCo, so there should be sufficient safeguard in place. Of course, I do understand that the authority wants to increase its flexibility, and you might want to add or take away some requirements from time to time. But I want to understand, comparing the width of the door, do you think there's a need to tighten things a bit here? Director, we will, after the meeting, see what can be done and what should be kept or what can be removed. Because Section 11 already mentioned some stringent requirements. Now, here you're talking about additional criteria. I'm just a bit worried about that. And, okay. The PMCs. There may be a requirement on, that it should have enough directors. But should there be a change in the number of directors? Or if a director is replaced, then any provision on that? Chairman, I think we sort of answered it before. If a company, a licensed company, has major changes, including the number of directors, then in a designated time, it needs to inform the authority. And then the authority would look at the legal requirement. If there's a requirement for a minimum number of directors for Tier 1 or Tier 2 license, then the authority has the power to suspend the license or even revoke the license if the number falls short of what's required. Members, any other questions on Section 15? Views? So I'll ask the administration to consider, as Paul Chair just mentioned. I think earlier on, other members expressed the same concern as well, that the worry that we may be giving the authority too much power, and how we can that the legislature will be able to vet, further changes in requirements or criteria imposed by the authority. So administration, please look into it and let us know your response and your final suggestions in writing. Okay, I think we finished part 3. So now we are on to part 4 of the bill. Mr. Kwok, is it? Section 16, subsection 1 and 2. Yeah, thank you, Chairman. Part 4 of the bill lays out the duties of licensed PMCs. A licensed PMC is obliged to provide to its clients draft budget, revised budget, bank records, and accounts, and any conflict between the interests of PMC and the interests of PMC's clients. And in Section 1, a licensed PMC must also prepare the prescribed information and provide information to its clients. And the authority may, by regulation, prescribe the information and manner for the purposes of the previous section. So members, any views? Claudia Mo? Thank you, Chairman. Assume, let's imagine this scenario, that this licensee is particularly friendly with a particular household and allows this household owner or tenant to put some unwanted goods or miscellaneous objects in the staircase. I'm referring to 16(3)(d). Here it mentions about any conflict between the interests of the PMC and the interests of the PMC's clients. So if the licensee could be, actually this could put the licensee in a, difficult situation. For example, if a household wants to make a complaint, then how can the household tenant or owner lodge a complaint against any PMC? I think in the future the authority would lay down some detailed code of practice so that the clients would know what they can complain to the licensee about. And also, at the same time, we protect the interests of PMCs. Sometimes some complaints could be really, groundless, and they could cause a lot of nuisance. So I think there will be the code of practice as the basis for the licensee to handle reasonable complaints and not be bothered by really groundless ones. So you are going to produce a detailed code of practice to protect the licensees, right? Yes. Would you, Vice Chairman? I want to find out further. Section 16, where it says the PMC must provide information to its clients. The way it's written here, though, gives me the impression that it's talking about PMC, the company's own information, but not information about a building. Is my understanding correct? Is it the responsibility of the PMC to disclose to its client, namely owners of the building it's managing? That is, as a client, under Section 16 here, it can ask the company for all its financial records and accounts. Is that right? Or are we talking about a narrower scope here? That are we referring to only information of accounts of financial statements of the building being managed? Mr. Kwok? I think my understanding is referring to information about the information being managed, but not all information. So Section 16, shouldn't it actually be more explicit about the type of information that should be provided? Well, actually, in Part 3, indeed, it stated what the information is required. No, that is information related to the building being managed, not all other information. Vice Chairman, any follow-up? Let me read it again. Yeah. Ip Kwong Him. I think the wordings used in 16.3, it means it used the word may. May include. So that doesn't mean that the information prescribed what is to be included is not necessarily the following information. Well, the word may doesn't mean it's optional, but it means that it actually means that the PMC must provide those information. Can you explain again? It means that the subsidiary legislation can ask for this. Well, let me try to explain. The PMC must provide prescribed information and in a prescribed manner. And subsection 3 mentions what this prescribed information contain. So in other words, the clients can ask for this sort of information. Right? Okay. The authority? Actually, the information to be asked for by the authority is also mentioned. It is covered in Part 3. Yes, it's about what is covered by the ordinance, by the bill. Legal advisor? I think for Section 16 here, last time we suggested that the administration could consider once the authority, a company receives notice from the authority that would not renew its license or it would revoke its license, then would it be a duty of the PMC to notify of the clients immediately should it receive such notice from the authority? Yes, we can consider that, yes. We can consider adding that too. Chairman, it's not that they can consider it, but I think our legal advisor actually made a very good point. This is something that should be added to the bill. The client is obliged to let the clients know. Yes, I think what we meant is we would make an amendment to make sure that it stated the company will inform its clients of any change. Vice Chairman, I think our legislative intent for Section 16 is that a client should be able to obtain from the PMC's information about the building concerned. For example, is budget, revised budget, books, records, and accounts. I think there's, I think at the beginning of the bill, there is actually an explanation on the meaning of the wordings here. So since we're talking about the information about the property being managed, so I think we need to state very clearly that this is about the duty of the licensee to provide to his clients information about the property concerned. I think we need to make it even clearer here. Mr. Kwok? Thank you, Chairman. I think the way that it's drafted already sends a very clear message. Basically, it empowers or authorizes the authority to make those requirements. I don't think there's a need to further amend the wordings. Vice Chairman?
Well, I just read out a paragraph, and I feel that it's unclear. Let's read it out again.
因為你個用語咧係會
Because property owners may argue with you, so you better put it more clearly. And Deputy Chairman also mentioned another point, and in relation to the word client, the definition should be clear. Are they property owners? Yes, we'll go back and consider all the points raised by members. Any other questions on clause 16? Mr. Wong Kwok Heng. Chairman, sorry, I need to dash between two meetings at the same time, so I don't know whether my question has been asked, so please remind me if it has been asked. On providing information to clients, for the PMC sector and the OCs, they are facing one problem. I don't know whether this can be dealt with in the bill. There are some PMCs under a group managing many housing estates, and they just mix all the statistics together. When an OC asks for information relating to their housing estate only, very often it's difficult to get this information. Even if the PMC is willing to provide information, the OC or the property owner making such inquiry would need to wait for a long time. So they can't provide the information in a timely manner. And that as a result, a misunderstanding arises. The delay may not have been deliberate. So this is actually a problem relating to lack of separate accounts. Say, let me give you an example. Electricity bills. Say the PMC group may be managing 20 housing estates, and they just put all the bills under one account. So things may not be clear. So I don't know whether the bill can address this issue of having separate account for individual housing estates. Thank you, Mr. Wong, for your question. Your question actually points out the crux of the matter, and that is why we are proposing this bill to set up a licensing regime to tackle this problem. One of the licensing requirements is that the PMC should prepare a separate account for the housing estate managed under its management for inspection by the property owners and the OCs, and the account should be prepared in a particular format. Otherwise, they may be subject, or they're liable to have their license revoked. And this may, by and large, resolve the issue facing OCs at the moment. Thank you for your clear response. Because for individual property owners, they've been facing the same problem over decades. I'd like to know the designated time frame and the designated format. Are you going to use standard forms? Now, at the advisory committee stage, we considered these issues in great detail. When we come to the subsidiary legislation, members will be able to look at such information. I thank the government department for your work, because this is actually the crux of the matter, and the devil is in the details. If the subsidiary legislation is not clear, then it will not be able to safeguard the rights of individual property owners. But I welcome the government's effort. About subsidiary legislation, I think a lot of details will be set out there, and we will urge the government to give national members more time to scrutinize the subsidiary legislation. Yes, we'll table it well in advance for members' reference. Any other questions on Clause 16? If not, then Mr. Kwok, you may continue with Clause 17. Now, Clause 17 is about a licensee's duty to notify change of prescribed matters. The licensee must notify the authority in writing of any change in the prescribed matters in the prescribed manner. And for the purposes of subsection 1, the authority may, by regulation, prescribe the matters and manner. So this is an enabling provision. Any questions from members? Legal advisor. Thank you, Chairman. This is not about Clause 17, but I have a question on Part 4, duties of licensees. We did ask in writing that in relation to money received from clients, maintenance fees, management fees, etc., how would the money be managed? Any provision? Mr. Kwok, thank you. Actually, we replied in writing, and we agree that regulations can be made, that when the PMC receives funds from clients, they should be subject to regulation. Now, we are minded to set out these requirements in the codes of practice, and we'll also consider setting out the relevant provisions for the PMCs to comply with these requirements. Mr. Wong Kwok Hing. Thank you, Chairman. About notifying the authority of any change in the prescribed matters in the prescribed manner, of course I welcome that. But I think it is equally important for the licensee to notify their clients as well. That should be a requirement. Otherwise, the OCs of the property owners may not know about the change in the PMC, whether there is any change in the duties and responsibilities. If the licensee can notify their clients as well, then this would be better. But there is no such requirement here. No, we do have this requirement. The licensee should notify the authority in writing of any change. But in our code of practice in future, we're going to require the licensee to notify the client of the same relevant changes within a certain time frame. I want to know about the notification. Would it be done in writing, or is there any arrangement to acknowledge the receipt of the notification in writing to ensure that the OCs will really receive the notice? Because my concern is that they may, as a matter of formalities, inform the authority, but as far as the clients are concerned, they may not be clear about the change. Details will be set out in the code of practice in future. We will also require the PMCs to put up notices in conspicuous places and notice boards within the housing estates to inform the clients. The details will be set out later. Well, if so, I welcome it, because we need to ensure that the property owner's right to know can be protected, because in the past, some PMCs may be operating under a group, and when there are changes in the group structure, clients may not know of the change immediately, and their rights cannot be safeguarded. So please note the situation. Any follow-up? Mr. Lam Chi-Chang. Well, just now, it is said that the licensee should notify the authority of any change within a certain time frame. But as I heard from stakeholders, sometimes they no longer engage a PMC to manage the housing estate, and yet they are unable to provide information about the accounts. So will there be any requirement that the PMC should provide account information within a certain time frame, or the license will be revoked? Yes, this is another important issue, and we did look into that last time. We're going to require licensed PMCs not only to keep a proper record of the account information and the correspondence. They would also be required to make disclosure to the clients in a timely manner. And when they cease to be the PMC of the housing estate, they are required to transfer the information and records to the next PMC. Failing to do so will be a breach, which may lead to a revocation of a license. So we do have this requirement. I want to know that this clause doesn't cover that. It's in another clause. Now these are details in relation to the format, the time frame, transfer of information from one PMC to the next. Well, these details will be set out in the Code of Practice and Guidelines later. Will we be able to scrutinize them as well? They will be done by subsidiary legislation. Yes, so we can check it later. Mr. Wong Kok-heng. Now to pick up on Mr. Lam Chi-Chang's point, the code will be included in the subsidiary legislation in future. Right, this is important because smooth transition of PMCs is important. I had this experience. This is important. And in the code of practice in future, we should include all the requirements in great details in order to balance the interest of all parties. All right, noted. So about the two clauses in part 4, any other comments? If not, we can move on to part 5. Well, we have an engagement at 12:15. May I suggest we pause here and scrutinize part 5 at the next meeting? Any views? Well, all right, so perhaps we should wrap up here. At the end of part 4, we still have 10 minutes left, but as everyone believes that more time is needed we still have time to scrutinize the remaining clauses. We'll wrap up here. So if there's no other business, I adjourn the meeting here. Thank you.